What else do I really need to know about getting a green card for my spouse? Marriage-based green cards are one of the most common ways to bring a spouse to the United States, but they're also one of the most stressful processes to navigate. In this video, I'm answering 20 of the most common questions I get from couples about the marriage green card process. If you're researching this for yourself or for your spouse, this is your shortcut. These are the questions I get asked all the time that didn't make it into my marriage green card series. So I wanted to answer them real quick in one place. I'm Giselle Rodriguez, founder of the law offices of Giselle Rodriguez in Boston. If you're new to this channel, subscribe so you don't miss the rest. Before we get into the questions, this video is general information only. It is not legal advice. Every situation is different. If you are working on this, please speak to an immigration attorney about your specific case. How much does it cost to get a green card for my spouse? The government filing fees alone usually run between $2,000 and $3,000 per case. That covers the sponsorship petition, the green card application, work and travel documents, if you file them, and the biometrics fee. On top of that, you'll pay for the medical exam, document translations, passport photos, and travel to interviews. Attorneys' fees are separate. Most cases run $2,000 to $6,000 in attorney fees on top of government costs. Do I have to pay separately if my spouse and I file at the same time? Each form has its own fee, but you can file most of them together as one package. When your spouse is inside the U.S., the sponsorship petition, the green card application, and the work and travel permits all get filed at the same time, but each has its own filing fees. There is no bundle discount. Plan your budget for the total, not just the first form. How long does it take to get a green card for my spouse? If you're a U.S. citizen and your spouse is inside the U.S., the whole process may take between 8 and 14 months. If your spouse is outside the U.S., consular processing typically runs 12 to 18 months after the sponsorship petition is approved. If you're a green card holder rather than a U.S. citizen, you may need to add another 1 to 3 years because visa availability backlogs. Every case is different. These are averages, not guarantees. Why is my spouse's green card taking so long if I'm a U.S. citizen? Even U.S. citizen cases involve multiple steps and multiple agencies. The sponsorship petition has to be approved by USCIS. The green card application has to be processed. The interview has to be scheduled at your local field office, and any background check that flags has to be cleared. Delays usually happen at the field office level because of interview scheduling backlogs. As of 2026, USCIS requires an in-person interview on every marriage case, which adds scheduling time. Can I pay extra to speed up my spouse's green card? No, premium processing is not available for marriage-based adjustment of status cases or related immigrant petition for this type of case. While USCIS offers premium processing for certain employment-based petitions and applications, it is not available for family-based I-130 petitions filed for spouses or for the I-485 adjustment of status application. Can I sponsor my spouse if I'm a green card holder and not a U.S. citizen? Yes. Green card holders can sponsor a spouse for a green card, but the process is usually slower than for U.S. citizens because of an annual visa cap in this category. As of 2026, the wait is typically 1 to 3 years just for the sponsorship petition. If you naturalize during the process, you can upgrade the case to immediate relative status and skip the wait. That's often the smart strategic move. Does my marriage have to be in the U.S. for it to count? No. U.S. immigration law recognizes marriages performed anywhere in the world, as long as the marriage was legally valid in the place where it happened. A marriage in Mexico, the Philippines, India, or any other country counts, as long as you have a properly issued and certified marriage certificate. Proxy marriages, where one spouse isn't physically present, have stricter requirements and may not be recognized without consummation. Can I get a green card for my spouse if they came to the U.S. without papers? It depends on how they entered. If your spouse entered without inspection, meaning they crossed the border without being checked by an immigration officer, they generally cannot apply for a green card from inside the U.S. They would have to leave and apply through a U.S. embassy abroad, but leaving triggers a 3-year or 10-year bar. Waivers exist in some cases. This is one of the most complicated situations in immigration law. Do not file anything before speaking to an immigration attorney first. Can my spouse get a green card if they overstayed their visa? If you're a U.S. citizen, yes. A visa overstay alone does not usually block your spouse from getting a green card. Your spouse can typically apply from inside the U.S. If you're a green card holder, the rules are stricter, and overstay can block adjustment from inside the country. The key factor is whether your spouse entered with inspection, not whether they overstayed. Can my spouse work while we wait for the green card? Yes, if you file from inside the US. When your spouse files the green card application, they can file for a work permit at the same time, and they may usually receive it within a few months. The work permit is generally valid for 2 years and can be renewed if the case is still pending. If your spouse is applying from abroad from a US embassy, they cannot work in the US until they enter with their immigrant visa. Can my spouse travel outside the US while the green card is pending? If your spouse is inside the US and has a pending green card application, they need to apply for an advance parole document before leaving the country. Traveling without it is treated as abandoning your green card application. Once your spouse has the advance parole document, they can travel internationally and return. But please note that re-entry into the United States is not guaranteed by using this advance parole document. If your spouse is abroad applying through an embassy, they can travel normally, but should not enter the US on a tourist visa with the intent to stay. Can my spouse bring their kids from a previous marriage when they get a green card? Yes, in most cases. Unmarried children under 21 are considered derivative beneficiaries. They can apply for their own green cards based on your spouse's case. If you're a U.S. citizen, you can also petition for your stepchildren directly, as long as the marriage to your spouse took place before the child turned 18. The rules are specific. Get the timing right and you can bring the whole family in one case. What happens to my stepchildren's immigration status? If your stepchild was under 18 when you married their parent, you can petition for them as your stepchild, separately from your spouse's case. This is a powerful option because it treats them as your own child for immigration purposes. If your stepchild was 18 or older when you got married, this option is not available. Birth certificates, your marriage certificate, and proof of any prior divorce or death of the other parent are required. Does my spouse have to take my last name on the green card? No, a name change is not required for a marriage green card. USCIS recognizes whatever name your spouse legally uses, and there is no preference one way or another. The most important factor is consistency. Make sure the name on the application matches the name on the passport, marriage certificate, and other documents. If your spouse does want to change their name, they can usually do so via the marriage certificate. Will an old arrest or DUI stop my spouse from getting a green card? It can, but not automatically. USCIS reviews any criminal history under the good moral character standard and the inadmissibility grounds in the law. A single old DUI may not be disqualifying. Multiple DUIs, recent DUIs, or DUIs involving injury or aggravating factors are much more dangerous. Certain crimes like drug offenses, fraud, and crimes of moral turpitude can permanently bar a green card. Pull your spouse's record before you file and speak to an attorney about how to present it. Will a big age difference between us hurt our case? Not on its own, but it can prompt USCIS to ask more questions. A significant age gap is one of the several factors officers look at when assessing whether a marriage is bona fide. Others include a short engagement period, limited common language, or living at different addresses. None of these are disqualifying. They just mean that the officer will want stronger evidence that the marriage is real. Bring more documentation, not less. What happens to my spouse's green card if we get divorced? It depends on when the divorce happens. If your spouse already has a 10-year green card, divorce does not affect their status. If your spouse has a 2-year conditional green card and you divorce before the conditions are removed, your spouse can still file the petition alone with a waiver, usually based on the marriage being bona fide when entered. If divorce happens while the case is still pending, the entire green card application can be denied. The timing matters. What happens to my spouse's green card if I die before it's approved? Your spouse may still be able to complete the case under widow or widower provisions, but the rules are strict. If you were a U.S. citizen at the time of your death and your spouse files within 2 years, your spouse can self-petition for a green card without you. If you were a green card holder, the rules are different and more limited. Speak with an attorney quickly. The 2-year window is firm. How soon can my spouse apply for U.S. citizenship after getting the green card? 3 years if you stay married. Spouses of U.S. citizens qualify for an accelerated path to naturalization. They can apply after just 3 years as a green card holders instead of the standard 5. The marriage has to still be intact at the time of filing and at the time of the oath. If you divorce before the 3 years, your spouse has to wait the full 5 years like everyone else. Do I need a lawyer to get a green card for my spouse? Not for every case, but for many of them, yes. Simple cases, both spouses inside the US, clean immigration history, clean criminal records, married for several years, can sometimes be handled without an attorney. These cases that go wrong usually involve a complication people didn't know to flag. Entry without inspection, prior visa overstay, criminal history, a prior immigration denial, or a marriage that started right before the visa expired. If any of that applies, get an attorney involved before you file. Marriage-based immigration is personal. You're not filing paperwork. You're building a life with someone. The system has rules. The rules have deadlines. And getting both right is what turns a stressful process into a finished one. The questions in this video cover what most people ask, but they don't replace a real conversation about your specific situation. If your situation involves a prior unlawful presence, an entry without inspection, criminal history, a prior denied application, or a complicated family relationship, please speak to an attorney before you file anything. Filing the wrong way in those situations can delay your case by years, and in some cases, it can trigger consequences that can take a decade to undo. An attorney's job here is to tell you honestly what your real options are before you take a step that can make things worse. If you want help walking through our situation, call our office or visit our website. The information is in the description. Book a consultation and we'll tell you exactly where you stand. I'm attorney Giselle Rodriguez. You've got this.